ये देखिए हम लोग के पास है, 1 नंबर पास है। देखना पड़ेगा सिस्टम।
Honorable Chief Justice, to immediately listing this matter because I am a dismissal employee. It could allow the writ petition. You know what I mean? I understand they are enjoying the stay. The Honorable Chief Justice fixed the matter today, but after due to determination change, my lord,
If it was fixed, it will come back.
it has not been fixed. Only my lord has said it will be fixed on 17, but it has not.
So his lordship must have accepted a slip.
I have given the slip there.
So if that is there, then it will be taken up. Find out if there is any slip for this case. If it is accepted, list it. Otherwise, if there is a stay, you should file a stay vacating petition. Application.
All the supplementary affidavit I have made a reply.
226, sir. Within 2 weeks. Please read Article 226. Yes.
Yes.
Yes. Yes, all inclusions you can give. For inclusion, anybody has a matter, please give it.
The contempt application which is made returnable before the honorable single bench
When? This month.
the expiry of 4 weeks on the date from the date of passing of the order in the contempt jurisdiction. Not we preferred a stay application with an appeal with a stay application. It could be taken up.
Application,
Stay application.
have you served?
Yes.
Let us have it on Thursday. Oh, sorry, can't be Thursday. It will be Friday. It will be fine. Friday. Tomorrow. Yes. Can you please inform the other side? All right.
Lordship, may I have the leave to file mandamus appeal without the certified copy? I have applied for the certified copy. The next day the order was passed, but till date I have not received it.
What is the date of the order?
Date of the order is 3 orders are there. 3rd of September, 10th of September, 17th of September. The 2 next orders were the orders wherein corrections were brought in, and in a
the limitation is long over.
Your
What is the
Lordship,
urgency?
vacation was there during October month.
This is not allotted to us. Today, this.
Your Lordship, vacation was there during October month, as a result of which I'm covered. I'm still, the limitation period has not expired, Your Lordship. And the problem is that the second orders wherein corrections were brought in, the Honorable Judge had passed an order that make corrections in the judgment itself, which is not the procedure here we follow. The corrections are to be read along with the main judgment.
What is the big deal?
So that's why
if it is reprinted, what is the big deal?
That's why department is not able to publish the main judgment. We have applied, but we have not received it. And it's a bad law which has been let down. Autonomous body has been given the same pay scale as applicable to Defense Research Organization, which is not at all applicable to the organization. It's a central
one of the units.
Your Lordship. So Departments of Science and Technology.
Before it is to be, we are to take up this matter.
Mandamus appeal, Your Lordship.
It is not a cat matter.
No, it is not a cat matter.
Well, file it.
Much of.
Give an undertaking regarding supply.
Your Lordship.
With leave.
93. Yes. Tomorrow, let it come.
My lord,
to be mentioned. Huh? You have given the number on the slip. Have you given a number? Give a slip, please. Please give a slip. Mr. Mukherjee, ask someone to give a slip. Yes.
my lord, praying for leave from your lordship and Honorable Justice Prosenjit বিশ্বাস.
that one matter, review matter, my lord. 2 times that has been mentioned, but yet to come before your lordship and Honorable Justice Supreme Bhattacharya to kindly consider this case.
Give the slip, we'll see when the bench is constituted, it will be listed.
My lord,
What matter? Hearing, please wait till next week. We are sorting out hearings. This Thursday, probably we will be in a position to list the hearing matters on a particular day. Then when it is, day is assigned, then we'll see. Right now. In every case, there must be something like this. Yes.
Lord, item number,
Please wait till next week. After
item
next week, you may mention.
item number 68 of today's list, my lord, it's an assigned matter. I have mentioned it on Friday. There is some urgency, my lord. Advertisement have been published. Any day, my lord, online application form, my lord, they will seek for TET 2022.
So when they seek the, if it is not taken up, you mention on the day they put up an advert. Why?
They wanted to mention the matter, my lord, of Honorable Division Bench of Justice Jamil, my lord. I mentioned this part of the last.
Oh yes, interim order.
Now I'm mentioning upon notice, my lord.
Now interim order is over. What is?
Still the next returnable date, my lord.
Yeah.
It was 12th November, but the matter has not been listed, my lord.
Then what is to be done? You can't say both things.
My lord, I'm not.
You are saying both things. One is that it has lapsed, the other is that it is going on. What is to be done?
My lord, let it appear as to be mentioned tomorrow, my lord, because my client will suffer great prejudice, my lord.
Then if it is over, then what is to be done? That's what we are asking you. You say no, it is not over because returnable date there is, it has not.
Order, my lord.
You can't say both things at this in the same breath.
My lord, I tried to serve in all modes to the advocate.
You are for the you are mentioning for on behalf of the appellant.
Yes. Today they have to report before the Chief Labor Commissioner, my lord.
It is suspended till the next returnable date. Why are you mentioning? It has not come back.
But if we have to report it before the Chief.
So you see this order is clear. Has not come back. Why you are worried? Yes. Why, sir?
September. There was a correct this correction. That correction was made after DOP. After correction, I applied for certificate.
All right. You give an undertaking for this.
Are on the verge of 18 years and the case is not given the pension. Well, summons of our having suffered from cancer and likewise, like I have been suffering from cancer. In this state, we have no, we are not.
Where is the last order? To us. Right. Yes.
My lord,
Yes.
lordship, may I have my lord's kindly
It will come on Friday. Yes.
My lord, this is also a group 3 matter. My lord, the interim order was, my lord, till today. I was
Okay.
My lord, since my lord has determination from today till 1st December of Honorable Justice Jamir and Rai
What do you want? What is the
for extension of interim order, my lord, it is expiring today, my lord. My
Let
lord,
us see the order.
while other side is
My
here.
lord, I am opposing this application.
17th, my lord, 17th is the next date and the interim order till the next returnable date. My lord, Mr. Gupta is my other side.
Till next returnable date, it has not come back. Why are you worried?
Because my lord, since 17th has been, my lord, indicated in the order.
Before the appropriate bank matter shall be listed, or
My lord, only extension and before the regular payment. My lord, my other side is also here, your lordship, kindly.
What is going to happen? What is happening today that it has to be extended? See, the notification is for urgent matters. What is the urgency today that if this is not extended, what will happen? Let the bench be available. Yes.
That lordship, as per direction of the STA, I purchased vehicle.
As per direction of
STA authority. I purchased my vehicle, but till date cannot fly my vehicle because they did not renew my permit. And this is the main problem. I filed the petition appeal before the puja vacation, and the court will normal court will sit on after 1st December, lordship.
so what is going to happen? Wait another.
My vehicle, lordship.
Not a big deal. Yes.
My
Yes, understood. Yes.
Madam Lord, COST 2 of 2009 Lord matter. Matter is pending of Lord. Suppose the original application filed with the administrative.
Can you please use the mic, please?
My Lord, the original application is filed with the state administrative tribunal, Lord, and
What is the matter pending? It's an appeal arising out of state administrative tribunal.
no, my Lord.
Then
It's a COST 2 of 2009, my Lord. Lord, even a contempt application is filed before the tribunal, my Lord. I cannot withdraw my salary, my Lord. My salary has been stayed. I'm the
2009.
Yes, my Lord. 2009. I was a respondent over there, my Lord. And it was filed by the petition state of West Bengal and others, my Lord.
It is admitted.
My Lord, it was not even money. In the status, it's showing it's pending, my Lord. Nothing.
Pending means for hearing for what stage? Find out, then you mention. Yes.
My lord, I beg to mention one matter for inclusion, my lord. Hearing, my lord, group 6.
Give the inclusion.
Lordship, may I permit explaining for hearing? Matter.
No, hearing after next week you mention. Yes.
Item number 1.
I beg to appear for the petition.
Yes.
Matter has already been settled before the mediation, lordship.
What is the settlement?
Yes.
What is the settlement?
My lord, it has been apportioned in 40 to 60, my lord. 40 for petitioner and 60 for the son of the deceased, my lord.
You are the sister.
I'm the sister, my lord.
So who is for the state? Not required if they are saying you. Page number 2. You were not nominated.
But I was the nominee.
Oh, yes, you were nominated. He was not
I
nominated.
am the son. I am not known. At that time, I was minor.
Not is not relevant.
সিঙ্গেল বেঞ্চটা নিয়ে চলে এসছে এটা
So where is your settlement? Is there any record?
Terms of settlement was drawn up, my lord, by the learned mediators. My lord,
Oh, it was done there.
Yes, it was done. We mentioned it also before the mediation that kindly send the file, my lord.
We are informed by the learned advocates representing
Grateful, my lord.
কোথায় পাঠাতে হবে yes immediate item number 2
Please, Your Lordship. Lord, we did serve Your Lordship, but the private respondent didn't. It came back unserved.
Oh, then
I don't know.
what then is the issue?
My lord, petitioner being the first wife of the deceased employee. My lord, she got married way back in the year 1984. And while she was residing in the village, and the employee, your lordship, he was working out here in Diamond Harbour Hospital. Here, your lordship,
A doctor.
she was the government employee.
He was a doctor.
No, he's a sweeper.
Sweeper in the hospital.
Yes, lordship. My lord, after the date he expired in the year 2011, we made application, your lordship, for the service benefits and for the pensionary benefits, your lordship. It was subsequently it was found that private respondent, your lordship, they were named as the nominee, and the private respondent, the first one, your lordship, she got married to her husband. This is the second marriage, and out of the wedlock there is two children. The other two private respondent, and taking note of the fact that only, my lord, they are the named nominee. Entire service benefits and retirement benefits and the pensionary benefits were given to them, released to them. Irrespective of the fact that we appeared, we showed all our credentials.
You showed what?
All our credentials showing that they are the husband and wife. Lordship, the birth certificate of a child, your lordship, the voter I card, along with the land documents. There are various the scheduled caste certificates, your lordship, wherein the name of the petitioner and the husband of the deceased employee is appearing. My lord, without considering the above, all those documents, your lordship, solely on the basis of the nomination papers,
how the nomination can be overlooked by the respondent authorities and how they can enter into this dispute.
By inquiry, your lordship, at least they should have looked into.
Where is the provision that a nomination can be ignored by the state, or it can be examined whether it is
but my lord,
to be
that
honored or not?
But my lord, the first wife's right shouldn't
You
be
may be.
curtailed.
Who is saying no? You may not be.
My lord, the order impugned itself shows that since the nomination is there, they only considered all those documents.
Therefore, again, we are asking you that nomination, which court can say it should be ignored? That's the only issue. You may be the first wife, you may be having a legitimate claim. We are not on that. But which is the forum which can say that no, you are the legitimate claimant and the nomination is for any reason, if at all, unsustainable in the eyes of law? Whether state administrative tribunal can say this? Can we say this in writ jurisdiction?
It's not that. That's what the court has tribunal has directed to take necessary steps. That is there. But in that occasion, your lordship, my lord,
and plus his death in 2011.
We are fighting since then.
This is a OA of 25.
This is the fourth one. This I think third one, your lordship. Third OA, your lordship.
Where whatever it is,
in OA 2011.
By now you could have got
2011
the issue adjudicated. It is now 14 years.
On the verge of collapse financially.
Must be.
Yes, lordship.
Must be. If you are consistently pursuing a forum which is a wrong forum, then you will collapse. What can be done?
Fighting since 2011. At least they should have considered.
You can continue to fight even after this.
That's
the point is, where is the fight supposed to be adjudicated? That is the only thing. How the tribunal can say who is the rightful claimant, who is the first wife, who is the second wife? And does the state have any scope to overlook the nomination and enter into this issue?
The laws of nomination is there, my lord. He is not to inherit what the person is entitled to. He or she will get it out. Only you ought to be acting as a manager and to distribute all the amounts if he is entitled to also.
To whom? Who will direct to distribute to whom?
The
tribunal or the writ court?
No, not the court.
Ultimately, you will have to avail those remedies. They will have to be noticed. They will have to be given an opportunity. There is a presumption in favor of the marriage that is sanctified by a nomination, which is the person who was married,
Lord,
whether
one
the
thing, Your
subsequent
Lordship,
marriage was without dissolution of the first marriage.
the authorities as well as
Even if the second marriage was without dissolution, what will be the rights of the children of both the parties?
the children,
So many things
that
has
is,
to be
my lord,
seen.
that is settled principle.
Who will decide? Who will decide?
That is a settled principle.
Who will decide? Who will decide?
But the one thing, Your Lordship, the petitioner's document, as it's appearing, Your Lordship, from page 12, these documents, they should have taken into consideration along with the nomination. They didn't. They totally failed to do that, Your Lordship. Well, can you look into the documents I had annexed?
Failure of which duty cast upon them under which provision? You are under judicial review. Failure of which duty under which provision? That was the first question we asked. You are compounding your own problems by pursuing this futile litigation, knowing well that you cannot get anything in this.
Have to go before the civil court.
Have to, you know that. There's no way. That must be what the tribunal has said.
Lastly, Your Lordship, it is stated. Lastly, by the last order, Your Lordship, it was
33.
stated.
Yes. She is the person who is the nominee, Shobha Roy, private respondent.
All three. Shobha Roy
and her children.
And the children. The children.
So all payments also made.
All payments being made.
Page? No, prior to this, he is saying they have moved the tribunal earlier also.
Yes, 2011.
Any earlier order?
2011. Can you look at
Any earlier order on record?
earlier order? Initially, we made an application. It was not considered. We moved before the Honorable Tribunal. The tribunal passed an order that was further not taken into consideration. We had to move before the tribunal once again. Thereafter, there is a direction, and pursuant to that direction, the authority concerned has passed that order.
Page 33.
Yes.
That is the order at page 33.
Yes. Fighting since 2011, and only this order was passed in the year 2024.
You also have children.
One kid. The first order of the tribunal at page 30, Your Lordship. This is way back in the year 2011 itself, 13 December 2012. Whereby the superintendent of Diamond Harbour Sub-divisional hospital is directed to dispose of the application. It was not done. And subsequent applications being filed.
ऑर्डर शीट नहीं কি লেখা আছে অর্ডার শিটটা নেই অর্ডার শিট পাওয়া যাচ্ছে
Yes, take the third learned advocate for the
Item number 3.
I am appealing for the petitioner, Lordship. Petitioner is a daily rated casual peon in the office. Petitioner was the daily rated casual peon in the office of respondent number 3. Since 2005 till 17, he was working continuously as a daily rated worker in a sanctioned post of Group D. Suddenly, he was terminated in July 2017 without any notice, Lordship.
Yes.
Thereafter, he made a representation against that illegal termination. Nothing has been considered. Therefore, he has filed an OA application before the administrative tribunal, and tribunal has given the liberty to make a further representation. And DM was requested to consider that request. Lordship, the order of DM is at page 48 and 49, Lordship. 57, Lordship. 56 is the order, 57 is the typed copy, Lordship. Without calling for any records, has come to a conclusion that he's not worked for 240 days. Lordship, there is a notification which I have annexed at page 30, Lordship.
You are showing us page 30.
Yes, Lordship. Clause 3, Roman 1. All contractual, casual, daily rated workers shall continue to be engagement up to the age of 60 years. Engagement of contractual, casual, daily rated workers shall not be terminated except as prescribed in above referred memo. Lordship, he has been terminated in spite of working for more than 10 years continuously without assigning any reason.
Where is the order of termination?
There is no order of termination. By verbally, he was terminated without assigning any reason, Lordship. Lordship, I have further challenged this order of DM in a OA proceedings, and the final order is at page 64.
This is the impugned order.
Yes, Lordship. 19 June 25.
That was just as a daily order. Nothing. Yes, so what is wrong with the order of the district magistrate?
Lordship, nowhere it is considered that why he was terminated without assigning any reason, and in spite of working daily rated casual worker, Lordship, he has been assigned work wherever he has worked there, and certain documents have been placed before the tribunal also, Lordship.
Which document? Hmm? Where it is?
Documents are not there, Lordship, but DM has not even called for any records to verify, Lordship, whether he has worked or not, because his statement was he is working. I have annexed the engagement letter, Lordship. Engagement letter
Your
is
contemporaneous claim is at page 32. Everything is much later and it cannot be. This is the contemporaneous claim immediately after they stop taking work from you. It does not even say since when you are working. There's nothing, no detail.
the engagement letter I have annexed, Lordship, at page 29, Lordship.
Maybe. So therefore, again we are saying 32 does not show anything. What has happened after 2005? You have worked 2 days, 20 days, 200 days, nobody knows. Nothing is there in page 32. It is only when you have got a representation made by some lawyer that everything has come. That also much later. And there is no material whatsoever. It is for you to make out, not for them to dispel the claim. How you have made out the claim, that is what we are going through the documents. We don't find any claim made out. You say I have worked, but they have never paid. And for 2005 to 17, 12 years, you have not raised any objection why you are not being paid. Is it believable?
The representation, he has stated that he has received 205 rupees per day as remuneration.
Correct.
The
At the
representation.
same time, you say that I have worked for 240 days in every year, but not paid. You are trying to make a pretext for not being able to substantiate the 240 days because you have not been paid. How can you show? You say it has not been done, I have been deprived, but you have not done anything for 12 years. Not nothing. Yes, I have done an advocate for the writ petitioner and the
Item number 4.
My lord, I am advocate for the petition not well since Friday. Kindly make this matter not today.
Not
Next.
5.
Mr. Islam is appearing in this matter, Lord. Praying for a week's adjournment, Lord. Mr. Islam is appearing in this matter for the petitioner, but I'm praying for a week's adjournment.
Why every day you are making a prayer for adjournment in this matter? You are not interested.
The service was complete only on 11th,
Huh?
Lord. Service was complete only on 11th, Lord.
What to do about service? You proceed with the matter. If there is any merit, we will ask you to serve. Earlier also, the matter has been adjourned at your instance. It cannot be adjourned every day. It is taken up. What is it? We proceed.
Lord, the impugned order is at page 47, my Lord. Praying for the correction of date of birth.
Just give us the basic facts. He has joined. He has joined service when?
Lord, he had joined service in the year 99, my Lord.
Give the date, sir.
The exact date, my Lord. My Lord, appointment letter was issued on 2nd of February 1999.
9. Yes.
Lord, may I briefly summarize the facts then, my Lord?
Please.
Lord, the petitioner hearing is an orphan, my Lord, was brought up in an orphanage in Howrah, my Lord. Later on, she was engaged as a helper cooker in a hostel.
Engaged as
a helper cooker, my Lord.
helper cooker.
Helper cooker, my Lord. In a hostel in Murshidabad. If your Lordship kindly comes to page 29 of the application.
Page
29 of the application. This is an appointment letter issued by the Directorate of Social Welfare, my Lord, appointing the petitioner as a Group D candidate, my Lord. It was issued on 15th of October 98. But for the purpose of granting this appointment, a medical certificate was issued, a medical examination was conducted, and a certificate was issued. That is at page 30. Very next page, my Lord. Now, if your Lordship notices, my Lord, her age at the bottom portion, it's given as 20, and the appearance also, it's given as 20 years, my Lord. Now, if your Lordship comes to the next page, my Lord, this is the verification roll that was prepared by the orphanage in Murshidabad, wherein the petitioner was working as a helper cooker, my Lord. At the bottom portion, my Lord, the date of birth of the petitioner is written as 30th July 1977. This is the date of birth I am praying for, my Lord. And thirdly, my Lord, I will like to draw your Lordship's attention to page 34 of the application. Lord, this is a release order issued by the orphanage in Murshidabad so that the petitioner can join his service as a Group D candidate at the CTP of Falta, my Lord. At the bottom portion, it is written that her date of birth, as per the official records, is on 30th July 1977. The typed copy is at the very next page, my Lord. So, my Lord, the petitioner joined his service with her date of birth as 30th July 1977. Now, thereafter, my Lord, I was transferred to two different offices. Firstly, CDPO Falta and thereafter CDPO Jiaganj. In the year 2019, when I asked for checking my service book regarding some casual leaves, I noticed that my date of birth has been erroneously recorded therein. Immediately thereafter, my Lord, I approached the tribunal, my Lord. The order, but I would like to draw your Lordship's attention to page 37, my Lord. It's the service book. Wherein my date of birth is erroneously recorded as 30th October 1969.
32, page 32.
Page 37 of the application. Page 37 of the application. No, my Lord, after may Proceed, my lord.
Where is the release order? 30/10/96. You were just showing us.
My lord, that release order is at page 34, my lord. But I made a representation to the authorities. It is at page 43, and thereafter filed an application before the tribunal. But the impugned order is at page 47. My lord, my application has been dismissed on the strength of a memo dated 24th of January 2012.
No, again we are asking you where is the release order referred to at page 37.
But that is at page 34.
That
34.
cannot be because the release order referred to at page 37 is number 248. We don't find any such number in this release order. What is the date on which you joined?
My lord, on 24th of 11th February 99.
You see at page 37 it says SMM Home Lilua wide number 248.
Yes, my lord.
Dated 30/10/96. Where is this 248?
My lord, write this, my lord. We do not have this memo, my lord. Write this memorandum, my lord. I was appointed as a helper cooker in that hostel in Berhampur, my lord.
248.
Yes, my lord. Write this memo. We have made this amendment in the OA, my lord.
Cannot be.
In para C of the OA, my lord, we are appointed as a helper cooker in Berhampur in the year 1996.
That's not the point. Point is, where is this release order? 248, because you have got this release order for appointment. You cannot say you don't know.
But we do not have a copy of this release order, my lord. Subsequent release order, my lord, we have.
Why you are withholding that from us? You are the person who will get the release order for your appointment. They have not got it. So why you are withholding it from us? And if you are withholding, then what is the inference? Because this does not show that date of birth is 37/97, 1997.
But the subsequent
Her
verification
date of birth as per official record as on 30th. So what is the official record of 30th July 1977?
What is the verification role that wherein I was working as a helper cooker, my lord, which is at page 31. I was working there as a helper cooker, my lord.
Page 31.
Page 31. This is the verification role, my lord, of that orphanage. Here very clearly, my lord, my date of birth has been given as 30th July 1978.
We don't know what is the date of this verification.
But the date of this verification is at the very next page, page 32, at the bottom portion, 7th of July 98.
Next page, page 32.
7th of June, yes, my lord. Page 32, at the bottom portion, 7th of
7th June, not July.
June, my lord. My apologies.
You also must be having this release order. If it is mentioned in the service book, you must be having it. Yes. Correct. So if that's all right, that is limiting your discretion. That is limiting your discretion. So let us see what is the release order which you have relied upon, because he is withholding that. He should have put on record this release order of 248
But that
mentioned at page 37.
that is with SMM Lilua, my lord. As
Cannot
the-
be. That is a release order you have got to get the appointment. Don't say that is with them. You are relying on this document. Don't make such statements. The document is very clear in what it says.
But the subsequent release orders, my lord, the
You
verification.
may get 10 more later. That's not the point. The point is that is the release order based on which entry was made. You are allowed to join. You may get more release orders.
Then, my lord, your lordship grants me time, my lord. I will shall come up with that.
No,
release
let them
order.
file a opposition. We will see. Yes, the petitioner and orphan
This order is being stabilized, Your Lordship. Praying for a not today, my lord.
Why these matters are repeatedly being adjourned? You are not interested in these matters?
Kindly grant me not today, my lord, because my senior.
Why every day, sir? Why every day?
This is only second time, my lord.
Only second. So what is the limit? After 3 times,
No, my lord,
it should be disallowed. What do you mean only second? It's a fresh matter. Every day you are seeking a Passover and then saying only second,
My lord,
as if it means nothing.
my lord, kindly give me a not today, my lord.
During pendency of the secondary petition. How the proceeding can be set aside? Tell us.
My lord, as a last chance, kindly give me a not today, my lord.
We asked you this question on the last day also. Question will remain the same.
As a last chance, kindly give me a not today, my lord.
Today again a prayer is made for adjournment.
Item number 7.
I appear for the petitioner, my lord. On the last occasion, your lordship directed me to file a supplementary affidavit. In terms of the leave granted by your lordship, supplementary affidavit has been filed. Copy has been served. Well, this is the affidavit of service. Thing is this, my lord, the second wife is before your lordship as petitioner. The government employee, my lord, died, my lord, after second marriage. Now, my lord, no disbursement of death benefit has taken place as yet. Blood, two issues of the first wife, well, they were not made parties inadvertently, but they have been made parties in the blood as per your lordship's leave granted. Blood, they are minor children. Blood, from the first wife, blood, two heirs, and from this petitioner, blood, petitioner has also got a son. Now, blood, the petitioner has prayed for very limited issue. Blood, petitioner has prayed for blood the family pension and death benefits. Blood,
Only that limited prayer.
no, not blood, not in full. Blood, portion. That is the limited prayer. Blood.
The first wife died in 2007.
Yes. We started living blood in 2009.
No, before that.
No, blood, the petitioner, blood, after death of the first wife, started living together with the blood, deceased employee blood, since 2009. Now, blood, they got married by way of registration blood, wrongly in 2012 because the petitioner divorce case was pending at that material point of time. Now the divorce case came to be
Act Suit 143.
yes, that came to be concluded in 2016. Immediately thereafter, after a couple of months,
Social marriage.
After a couple, and the petitioner and the husband of the petitioner died, and the husband of the petitioner died in 2017. So I being the only wife at the material point of time, I have got a definitely I have got a share subject to your lordship's kind consent.
How it can be considered in a writ proceeding?
No, we are challenging the propriety of the order passed by the tribunal.
Correct. So how the tribunal can go into the issue whether you are a legitimate claimant or not?
Tribunal did not interfere with the order passed by CMOH, Chief Medical Officer of Health.
So does CMOH have the jurisdiction to decide such an issue?
This is not an issue to be adjudicated subject to your lordship's kind.
The entry was made in the service records regarding your marriage.
That I cannot say.
No, whether you have said in the OA. Unless there is an entry made in the service records, how the authorities can consider such a thing?
Just a minute. But in fact, that is not an issue subject to your lordship's kind consideration to be decided by civil court, because this is regarding claim of death benefits. Now, claim of death benefits by a person admittedly.
Admittedly. So how admitted? Let us see. Who has admitted? CMOH has admitted.
CMOH has only considered the
So when you use the word admittedly, that means the respondent has admitted.
No, because there is no other claimant. There is no other claimant.
So therefore, any lady can come and say that I am wife and the authority should give it.
No, the question is the CMOH has wrongly decided the factum of marriage, considering the registration certificate. Admittedly, that registration was illegal because my divorce case was pending at that point of time. Now, thereafter, since we have socially married, that should have been considered by the CMOH. That has not been considered.
And the government employee is no more.
No, he died in 2017. And we got socially married in 2016.
Cannot be
So
decided.
we are only.
Where is the CMOH order?
Yes. Both of them. Each.
We have not been done.
No, supplementary 10 squares. Each Page 32 is the order in the first round of litigation by the tribunal. Page 32. Second round.
No, where is the order passed by the CMOH we are asking?
35. Page 35.
Yes.
But your lordship has seen blood. Serial number 3, my son has been included. Blood and blood at the right hand side, it is clearly written blood, the father Joy Das and mother Snigdha Das, the petitioner before your lordship. Now blood, everything was blood admitted that I am having a son, I am the wife of the deceased employee, but blood, the benefit has not been blood given in favor of the petitioner for the reason blood that the CMOH relied on the marriage registration certificate, which could not have been blood registered at the time when the divorce suit was pending. Now, blood, your lordship kindly sees this document was not taken note of, page 28, the blood invitation card for my social marriage. But that was not taken on record. Everything was taken on record, but social marriage was not taken on record. But there are blood two kinds of marriage provided in the Hindu Marriage Act. Lord, your lordship is aware. So, Lord, registration or social rituals. So, I was married socially. That was a valid marriage in 2016 during the lifetime of the deceased employee who died in 2017. Therefore,
You have not placed the card, you have not placed anything about social marriage. Before CMAH, you have not placed these things. How it can be considered? When it is rejected, perhaps then only you have either realized or got the card printed, whatever it is.
But in any case, but since my son has been admitted as a
Now
legal,
tell us one thing, even if you were not married to Joy Das and he was an illegitimate son, would he get the share?
son definitely will get this.
Therefore, that cannot be a proof of marriage.
No, I am not on that. But the thing is,
Just because he has been allowed, that does not mean marriage is proof. Even if there is no marriage, he will get it.
no, but the kindly consider one aspect.
And your admitted position is that on the day the marriage was subsisting, the certificate you have relied upon, that cannot be relied upon.
That's correct. That I am not pressing for that. But
Printing of one card will not confer a marital status.
Kindly, yes.
And whether that card is corroborated by the factum of marriage based on any evidence, that you can do it.
But only one thing, if your lordship kindly take note of 3 dates. These 3 dates are very important. The petitioner obtained decree of divorce on 7th April 2016.
Yes, in Mat Suit 143.
Yes. Now, on 20th June.
Therefore, we are saying whether there was a marriage on that day or only card was printed, neither we know nor anybody knows. So beyond the card, if you can corroborate that actually a marriage.
By way of affidavit, I am saying that I was married on 20th June. So affidavit is definitely I am affirming that I was.
Then there is no requirement of having any civil court. You affirm a fact on affidavit, it has to be accepted.
No, this is not such a critical issue.
Oh, it is a very critical issue.
It
is a very critical issue. Conferment of a marital status is not a very minor issue. It's not a very trivial issue. Conferment of marital status or recognition of a marital status is a very major issue.
I am not saying
whether you are a legally wedded wife or not. That is a very crucial issue.
I understand.
Many things will arise.
I understand. But
as
I'm not saying this is a trivial issue. But thing is this, the husband of the petitioner is no more in the world.
That hardly matters. The point is how to establish whether the card was only printed or apart from printing of the card, marriage also took place. How to establish this fact?
No,
when the card has not been relied upon before the CMOH, then how the tribunal can look into it.
Yes, now, your lordship kindly says what is the fact that I have disclosed.
Maybe not. So whether the card is corroborated by any factum of marriage, that has to be established. That the CMOH cannot determine, that the tribunal cannot determine, that we cannot determine.
Your lordship kindly consider what I have disclosed in my petition by way of affidavit. I obtained decree of divorce on April 7, 2016. Social marriage took place on 20th June 2016, and the incumbent died on 2nd March 2017. So on the basis thereof, since no dispute or denial has come from the.
Who will deny?
Either private respondents.
No, the point is an application is made to a government authority. There is nobody to dispute that, therefore he has to accept. We don't know any such law.
No, the government.
He is required to be satisfied on the basis of documents before him, whether the claim you are making is legitimate or not. The only document in support of your claim is a registration certificate much prior to annulment of your marriage. Whether such a conclusion of the authority is bad or not, that is the only thing.
The state could have disputed the facts disclosed in the original application. They have not disputed. সবই বলছি সবই ওগুলো ঠিকই আছে, কিন্তু বলছি যে হ্যাঁ ডিসকাস করবি। আর এটা তো কোর্ট ডিসাইড করবে না, সিভিল কোর্টে গিয়ে তোমাকে ডিটেস্টটা নিতে হতো। But on the other day, that your lordship observed. Now, the thing is this, since the first wife has already expired, now that nomination cannot be accepted as a valid document. Now, legal heirs, my son has been included as a legal heir. So, on the last occasion, your lordship observed that you served the other side, 2 children of the first wife. I have served. So, what I am on, only 4 shares. Your lordship kindly decides, let there be disbursement in equal 4 shares.
You have not relied on this card even in your claim before ACMOH. This is a card subsequently printed.
That I cannot say.
You can say, look to page 24, your application made before the ACMOH, BMOH. Nothing about this card, nothing about social marriage. Nothing about social marriage even in your OA. Even in your application before the tribunal, nothing about social marriage.
But if your lordship sees birth certificate is there.
Your entire claim today is based on the card, nothing else.
And birth certificate.
No, sir, birth certificate will not make you a married person. Birth certificate will only certify the birth of the child. That has nothing to do on your marital status. Regarding marital status, your only claim is based on a card. That card not referred before the CMOS, that card not referred in OA. How you have placed it in the writ petition? Therefore, we asked you.
No, OA card.
Nothing. And this is the way. So you will get a card printed.
In the supplementary affidavit.
Therefore, now we know it was not there. Therefore, we asked you to place it on record. This is not the way. Then before the higher forum, you will annex something else. So every day you will create a document to legitimize your claim. You will create a document.
In fact, the importance of the card, possibly could not have been.
There is nothing else on which you are basing your claim. Social marriage card, nothing else. And that also to defeat a registration issued by a statutory court forum. You want to that we should overlook that registration issued by a competent forum on the basis of card you have got printed after the OA. Wonderful.
The fact is this word.
That is the fact, sir. If the card was in existence, you would have stated in the OA. You please show from your OA any averment regarding the card. Nothing. This is not the way.
Lord, only one thing, Lord, I would humbly submit before your Lordship, Lord.
No, this is a misleading document.
Lord, I would
misrepresentation.
Lord, in fact, Lord, I would humbly submit before your Lordship, Lord, that Lord, the importance of the card, Lord, could not.
There is nothing apart from the card in support of your claim. Since you have started, you have been saying that there is a card, social marriage. That is the whole sheet anchor of your case.
And birth certificate is also there.
Please tell us one law that birth certificate will prove your marriage. Show us one law. Why you make such submission, knowing well what is the legal position? Why you make such supposition?
In the absence of any other claimant, Lord, your Lordship kindly consider.
Therefore, anyone should come, it should be given.
I don't.
Please make some legal sense. Don't make desperate submissions. Some legal sense in the wake of the fact that you have tried to misrepresent a claim in a writ proceeding.
May I suggest?
Why do you do such things?
May I suggest this, Lord? May I suggest this, Lord? Subject to your Lordship's kind consideration. Lord, I would humbly, Lord, submit that since, Lord, no card was referred before the Lord, Chief Medical Officer of FAME, Lord, let me have the liberty to produce.
No, not now. Surely not. This document created before filing the writ petition. Now you should be allowed to rely on that. Wonderful submission you are making.
Since it was not referred, Lord, I'm
nowhere. Neither before the state authority nor before the tribunal.
Straight away,
how the tribunal's order is bad when you have not referred to any such document?
Straight away, Lord, we should not disbelieve a document.
We will record why. Lord, the circumstances are speaking loud. How this card has been created. There is no other inference that can be drawn. There is no other possibility. This is not appreciated. Yes, disputes are there. We are listening to every dispute. But this way to mislead a forum, a writ proceeding, you will file a document.
Lord, apart from the card, Lord, I am not pressing the card for the time. Apart from the card, Lord, even if Lord, I take together as husband and wife without having any document in support of social marriage or valid marriage registration. Lord, even in that case,
yes.
Lord, even in that case, Lord, since Lord, we stayed together, we have got a child. Lord, he has been allowed to be a legal heir of the deceased employee. Lord, can I be just thrown away? Lord, even if I don't have the status of wife. Lord, I am putting a question to myself, Lord, subject to your Lordship's kind consideration. Because Lord, I on the other day, Lord, I tried to convince your Lordship, Lord, by submitting that.
The moment you relied on the card, there was a doubt in our minds.
I understand you.
Therefore, we asked you to place on record the OA.
Lord,
the doubt stands.
I understand. I appreciate your lordship's
supported by the
I
supplementary affidavit.
I appreciate your lordship's
Now, such a person, such a litigant, relying on documents created for the purpose of litigation.
I appreciate.
What is to be done? Will you please tell us
What has fallen from your
what such person deserves?
I
Forget about other merits. What such person
I
deserves?
fully appreciate what has fallen from your lordship. I don't press the card. But since it is
Now there is
doubtful,
now it is
and
there on affidavit.
Since your lordship has already observed that only inference can be drawn that it is a created
No,
document.
you tell us what
I
other inference.
I
You
fully
tell.
appreciate.
Yes.
I am not pressing.
Then-
I am not pressing the card. Since it was not pressed before the tribunal nor before the CMOH, I am not pressing it. I am not pressing it at all. But forgetting the social marriage or valid registration. But
In your application, there is nothing about any social marriage. Come again to page 32. What have you said? This is the representation, page 24 of your supplementary.
only
Please
quarters.
read.
I have read. Only quarters. Let me stay. He has expired on so and so. Let me stay there.
Don't even claim to be a married person.
I understand.
And now in a writ proceeding, this is the way. Article 226, Court of Equity, equitable jurisdiction. This is how you will file a writ petition.
I am not pressing the card. Let me have the liberty to withdraw the card. Not only thing not which not I am just not pointing out before your lordship. Not since not admittedly we have got a child. We stayed together for a long time since 2009. Not
Yeah, that's all.
But why? Well, I'm just saying that can I don't I have any right, blood? Even if I don't have any status of man. Since blood, my son has been included as a nothing has been disbursed.
Take down.
Nothing has been disbursed.
Or the learned senior advocate for the Hmm? Police department. As
Stereotype. The security control department.
so what is his claim?
That Madonna died during the period of COVID-19.
He died. Petitioner died.
Husband of the my husband died.
Yes.
That is the wife of the.
So what is your claim? Some benefit as a COVID warrior.
Addition of party.
What is the benefit you claim? Job. So he was not in a regular employment. Permanent employee. So if he has died, either way you will get a compassionate appointment. So why you are harping on how is it better?
I am in the way of by any means she will get a job. Otherwise, why will is the question? But only that the other means that is community in general. There is a question of vacancy.
Oh.
The question.
And in COVID warrior, there is no issue of
COVID, there is no vacancy.
Where is the policy?
That's one of what.
So what the tribunal has done?
Tribunal has done. Tribunal has done. You made an application for general appointment under competition ground.
No, see, if we remember correctly, we have seen the policy earlier. It is for the frontline workers. There is a concept of frontline worker. Now, how do you say that you qualify as a frontline worker? Page?
There is two categories.
Yes. Hmm? A, yes. Yes.
What is public undertaking, statutory body, or any branding. Under B, all the online parts. Both are eligible. I am on the first A. Online workers really means the health worker, paramedic staff.
You are working in the police department.
And the line of duty has to be considered, not considered. The judgment also.
So where is the claim you have made before them? Where is your claim that you have submitted? Yes.
Because, my lord, I have an unreported judgment.
Sir, judgment comes after the facts. Please be kind to me. How will I understand this? Page 27. I don't know what is your claim. I cannot decipher. Unless you do it, how I can understand? Where is the rejection order by the authority?
Your Lordship, there was no rejection. Your Lordship, kindly see page 39.
Yes.
Lordship, it has been stated that since he was a stenotypist and he was not engaged in COVID-19 related duties, he is not eligible under this particular regulation dated 2020. But she was eligible under the 251 EMP, and if she is agreeable, her employment shall be considered under 251 EMP. Lordship, if your Lordship kindly see page 40, clause 2, it clearly says the scheme will be applicable to a dependent family member of the following categories of the employee who, while on COVID-19 related duty.
So therefore, we were asking in page 27, what has she said? What duty he was performing? That's
He was performing a stenotypist. He was a stenographer.
no. What is said
Office.
in the office?
In the office, your Lordship, there we have attached the attendance registers also. He had been attending a few sessions in the office. That also considering the COVID-19 precautions, your Lordship. He had been on leave throughout during the COVID period. He had not. We have already annexed the attendance register also in the opposition.
Oh, you have filed an opposition also?
Yes, your Lordship.
Period of position of notification. I was on duty.
Your Lordship, kindly from page 12A.
Your opposition 12A.
12A, your Lordship. All the attendance registers have been given.
Serial number 4.
Number 5, your Lordship. Serial number 5. Lordship, they are attending 20th March and thereafter it's all blank, your Lordship. Even in June, few days he has worked. And more so, he was not a front line of COVID on any COVID-19 duty, your Lordship.
So 5 is some accountant.
Your Lordship, Mohan Chandra Moscow.
Certain names are inscribed by hand. So which one? 1, 2, 3, 4 is, it is 4 or 5? 5 is, 5 it says accountant.
The home, Your Lordship, the name just above 5, Your Lordship. Your Lordship, there is a hand-drawn line, Your Lordship.
Above accountant.
Above accountant, Your Lordship.
So that is 4. That's not 5.
I'm extremely sorry, Your Lordship. 4.
That's 4. So from June 2020, he has started working.
Yes, Your Lordship. Thereafter also he has taken, he was on June. July also, Your Lordship will see. He has worked only few days.
No, but he is coming to the office.
Coming to the office. Your Lordship, he was not on COVID-19 duty or he wasn't a frontline warrior, Your Lordship.
Where is the definition of frontline warrior?
Yes, Your Lordship, it is. I can indicate, Your Lordship. Your Lordship, the first paragraph, page 40. The introduction, Your Lordship.
Page?
Page 40, Your Lordship. The circular dated 12th August 2020.
We could not find any definitive parameter based on which.
Your Lordship, a large number of COVID warriors comprising of employees and contractual casual hired volunteers, state government such and such. Under the state government are working day and night, risking their lives to provide urgent medical treatment and other support service to the affected population and to enforce restrictions to ensure the containment of the pandemic. Many of those frontline warriors have themselves been affected by COVID and unfortunately suffer. Thereafter, Your Lordship, paragraph 2 clearly says this is only applicable for the dependents who were in COVID-19 related duty and during duty they had been affected. Your Lordship, one minute, Your Lordship. Can it be taken up tomorrow, Your Lordship? Some person.
All right. Not today.
Permit to mention my one minute.
Yes.
A quantum matter passed the way before Lordship, my lord. My matter was running in the list up to 12, my lord. My lord, I'm praying before Lordship next time when the main bench will be available, the matter will be come before Lordship.
Again, we are saying the same thing. When the bench is available, it will come.
Kindly listed.
You know that this bench is not regularly sitting, so it will come. Don't worry. When that day is there.
May I mention, my lord, it's contempt application. Petition is going to retire in December, and he is specially able person, my lord. His pension will be withheld.
But may I be permitted to bring to your lordship's kind notice that, my lord, WPST 76 of 2025, my lord, is pending for order, my lord. My lord, since my date for, my lord, neurological operation, my lord, OT, my lord, in the brain is awaiting, my lord. So, if your lordship kindly consider my prayer, my lord. No, my lord, I beseech your lordship's kind indulgence. No, my lord, I am not mentioning, I am bringing to your kind note. My lord, I know the lordship, but because of the predicament, my lord, I know this matter cannot be mentioned. My lord, due to the predicament, my lord, due to the predicament, my lord, I want to finish my responsibility of, my lord, bad or good, what is my lord, as your lord. No, my lord, since I am, my lord, I am overstressed. No, my lord, since I am overstressed, I am an officer of the court. I must disclose before your lordship what is, my lord, awaiting for me, because I know what predicament will come, good or bad. Because I was in Chennai hospital, and yes, that's why. Otherwise, Lord, my lord, my lord, that's enough, my lord. My,
You are under any problem, you will attend your treatment.
my, much obliged. Sorry, my lord, for bothering you, lords.
Item number 1 for judgment.
My lord, I am appearing on behalf of the appellant in this matter.
APT 157 of 2021. The ordering portion. Prayer sought for by the appellant is allowed.
So grateful, your lordship.
Allowed.
Item number 9.
I am appearing for the Public Service Commission.
I am appearing.
Before my learned friend starts, while going through the records, I found a small typographical error. Can I file a supplementary affidavit correcting that? Though it will not change the stand of commission. I'm serving it.
May I hand it over the
Please.
direction directed me to, and my lord will remember in this matter, my lord, the antonyms of pheresis and the last occasion, my lord.
You have not addressed this bench earlier.
My lord, I addressed. That's my lord. My lord will remember.
No, you have not addressed this bench earlier.
Oh, sorry. Yeah, yes, my lord. I'm extremely sorry. Yes, my lord. But this matter relating to my lord, PSC conducted examination where I challenged 4 questions, my lord. Question number 4H, question number 13, question number 9, and question number 3K. Out of 4 questions, after challenging through original application and in pursuance of the set order, I filed this WPST. In WPST, my lord, PSC filed an affidavit in opposition. In their affidavit in opposition, they agreed that they made a mistake. And they gave number 2 marks in respect of question number 4H. But in respect of other 3 questions, till now, they not give any number. And after giving this question number 4H number, that is 2 marks, my marks and last selected candidate marks is same. So if I got even half marks, then I will be the selected one. Total marks, my lord, involved in this matter, regarding, my lord, the challenge question is 15. Out of 15, my lord, in 4H, 2 marks is already allotted, my lord. That means 13 marks is under challenge, my lord. Now, my lord, wants to start, my lord, one question, that is question number 3K. Why I start it? Because in other petitioner who already awarded half marks by the PSC by giving the same answer, my lord. I just want to hand it over. On the last occasion where I indicate it, my lord, well, I want to hand it over my learned friend also, the copy of the original of application, my lord. May I hand it over, my lord? Original application of other petitioners, my lord, where the petitioner gave.
Your way is not part of the record.
No, my lord. Because of that, in the meanwhile, I just got it, my lord. Because in the way of certified copy, my lord, I got it. In original writ petition, first I placed my question.
How many petitioners are there?
One, single petition. First, what is the question? Kindly turn, my lord, page number 98 of the WPS writ petition. Page number 98. What is the question?
No, just a minute. What was the total marks?
In
Examination was on what total marks? Out of how much?
100 marks.
It
Full
was
marks.
out of 100. You have been awarded?
Out of, my lord, this 100 marks and as well as the other marks, total marks is 274 is the last candidate marks, 276.
We asked you how much you have got. 74 is the cutoff according to you.
276. 276.
Is the cutoff?
Yes.
Out of 100?
No. Total, out of total. According to the...
So the dispute is only in the written exam?
Yes.
So written
15.
was conducted on total 100 marks?
Yes, Maharaj.
What you were awarded for the written exam? What marks? How many marks?
Just Maharaj. Page number.
And this was for recruitment of?
Supervisor.
Supervisor in which department?
ICDS supervisor.
Oh.
Maharaj, kindly turn page number.
Supervisor ICDS?
ICDS supervisor.
It's under a scheme or it is a state?
No. ICDS supervisor post is conducted by the PSC. ICDS is a scheme, but the supervisor...
The state appoints the supervisor to oversee the ICDS. Yes.
Kindly turn page number 31. My marks is allocated. page number 31, entry number 6631. Page number 31. Various paper was there, my lord. There is 1, 2, 3, 4. 4 paper was there. Out of 4 paper, my lord, I secured 244 marks, my lord. Each paper contains, my lord, 100 marks.
So every paper was
Yes,
out
yes.
of 100.
And my lord,
244 out of 400.
yes, my lord. And 30 marks personality test.
Yes.
And 270 is my marks.
So 274 is the total.
Total marks, my lord.
Yes.
Kindly take, my lord, their ABDB in opposition filed by the PSC.
So just a minute. So if you are allowed, if your claim is allowed, you will secure instead of 244, how much?
Another 15 marks.
15.
Yes, my claim is 15 marks. They already agreed. Regarding 2 marks, they already given 2 marks.
So you will get 259.
279. 276.
279.
276.
So 259 plus 30.
Yes. My 274 already I get. So 274 plus 15. That means 289 is my claim.
That's what we are saying.
Out of 289, already they given 2 marks. That means already they given 276. That means.
So you will get 259 in written and your PT will remain 30.
Yes. That's.
So total 289.
289.
Yes.
But they already, out of that 15 marks claim, they already given 2 marks.
2 has been given.
Given. In question number 4H.
So that means you will get only 13 extra marks.
Yes.
Now you will get 13 extra marks.
Yes. My claim through this
additional 13 marks.
Additional 13 marks.
And what is the cutoff last?
276.
276.
After awarding 2 marks, my marks and last selected candidate marks is same.
Cutoff is 276.
Yes.
Yes.
Which I handed over. First, I start 4 questions is under challenge. I start, question number.
Question numbers?
3K.
No, which are the 4 questions?
3K. Question number in 4 different subject. One subject, that is question number 3K, page number 98. Kindly turn, page number 98, which is
3K in which question? In which paper?
English.
At page 98.
Yes.
The other question?
Other question number, other question number 13, page number 67.
In which paper?
Arithmetic.
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 Which page?
Page number, the specific page number 67.
Of the OA?
Yes, madam. No, WPST.
These pagings you are giving from the
yes, WPST. All pagination from the WPST.
And third question?
Third question is question number 9. That is page number 66. That is also from arithmetic.
From?
Arithmetic.
Arithmetic?
Yes, ma'am.
So one from mathematics and one from arithmetic?
No, madam. Both are from the arithmetic.
Arithmetic. There is no mathematics.
Mathematics. That says it as arithmetic. The branch of mathematics.
Yes, that's why we are.
Yes. They denoted it in the.
And the fourth question?
The fourth question is already awarded. Question number 4H. That is page number 4H. Already awarded, my lord. Page number.
In
40.
which paper?
General Studies and Current Affairs. GS and CA.
Which page?
Page number, specific page number 40.
40.
40. Question number 4H.
Yes.
So 1 from 4H already awarded. Question number 13 not yet awarded. Question number 9 not yet awarded. Question number 3K not yet awarded. Let's start from question number 3K. Why? Because of that, my lord, already this marks is awarded to the other candidates. Kindly turn page number 98. What was the question, my lord? 3K. May I read, my lord? Give
Yes,
the
answer
antonyms
is at page 100.
Yes, my lord. Answer is page 100. And antonyms of phrases is come. My lord, kindly take this original application copy which I handed over today, my lord. Kindly turn page number 36. K. Phrases antonyms come. Half marks is awarded to the other candidates. For me, that is 0. For other candidates, PSC given half marks. Even I got this half marks, I would be the selected one. Without going that arithmetic part.
So you have already got the cutoff marks.
Already got 276. Even half marks is awarded. I am the selected one.
No, but 276 the cutoff marks. So last selected candidate got 276.
276.
You are also having 276.
After adding 2 marks, I also 276.
Then why do you need any more marks?
Half marks, malad. This says because of that, malad, due to if same marks is awarded to candidates, then the date of birth is a considerable.
Oh, so
No,
the
Lordship,
person who is older in
there is
age,
a tie,
the
when there
person who is older in age, he will
No,
get.
Lordship, first condition is when there is a tie, the candidate who has secured more marks in personality test will be selected.
Okay.
Whatsoever.
So by that reason, the other person is
Other
selected.
person has selected. And the rest 3 questions, PSC has scrutinized as per the model answer and the arithmetic. He has not corrected, give the correct answer. That's why marks has not been awarded.
Obviously, you will sustain the grade. We are just trying to see
Where PSC has thought that he has given a correct answer, 2 marks has been given to him.
No, but he is saying that for this, the other has been awarded half marks.
Lordship, I have taken specific instruction. These are all subjective types of question. Some examiners follow the model answer
So
scripts.
there must be some kind of moderation is being done.
Lordship, I have got the model answer of this English paper, where in the model answer it is given the antonym of ferocious is meek and mild. Meek or mild. That's why
Meek, M-E-A-K.
M-E-E-K.
M-E-E-K, sorry.
Meek or mild. So, Lordship, it is the discretion of examiners. He has given instant of 3 candidates, and we have
And
found.
this is this question is for 2 marks.
Yes.
So he has been awarded half out of 2.
Yes. The Lordship, the thing is, different examiners correct question papers of different candidates.
1 mark.
We have. May I make my submission?
1 marks, not 2 marks, malad. 1 marks.
They are 1 marks each.
So, Lordship, different examiners, some follow the model answers, whatever is there in the model answers, and some use the discretion of giving half marks. So, Lordship, it is very difficult for PSC to ascertain because experts finalize the question,
No,
model
the other
answers.
thing is, if someone has been awarded marks wrongly, then the other person can also is not entitled to a wrong award of marks. Even if your model answers does not contain calm as an option, and someone has been given a marks for that, that will not entitle everyone to get marks for that. But what about the other two questions?
Other two questions he has given wrong answer, Lordship. Lordship will remember there was a question in arithmetic, who has to do more percentage of work, homework? The answer would be Meenakshi. She has to do more marks, more percentage of marks in homework. Just because any exam,
the law.
just because any one examiner has given marks for a wrong answer, we cannot allow.
Sure.
May I submit, my lord? Two things is there, my lord. One is that negative equity. Another is that
one is
negative equity. If someone got the, my lord, benefit of the wrong assessment, that I am not asking the negative equity. I have twofold prayer. One thing is that the PSC's setting answer key must not be sacrosanct.
The primary question that arises, whether such an issue is open to judicial review.
Yes, my lord. I bring the authority in this regard, my lord. And not only this type of situation, my lord, this Calcutta High Court passed several order. I will.
No, we are on the law laid down by the Apex Court.
Supreme Court. Yes, my lord. My lord, go down, my lord.
In that event, entire examination will be vitiated. We don't know which candidate has. This has come to our knowledge, Lordship. We have found he has given a wrong answer.
You have come with any judgment?
Yes.
No, Lordship.
You are supposed to be here with the judgment. The issue is whether judicial review can be invoked for such an issue or not. That is the issue.
Start from, my lord, Kanpur, my lord. The recent one, the Rishal, and following the Rishal, my lord.
Rishal
judgment, my lord. 2018.
2018
8 SCC, page 8.
2008.
18. 2018. 8 SCC, page 81. If this type of situation, my lord, arises, একটাই কপি আছে, আমি সাইটেশন বলে দিচ্ছি, তুমি লিখে নাও, একটাই কপি, আমি 3টে কপি এনেছিলাম। May I place the fact, my lord? 2018 8 SCC 81.
No, this is not going into answers.
Yes, my lord, kindly settle position.
This is whether when the marks have been revised, the benefit has to be given to all or not.
Yes.
We are not on that. We are on, can we go into this scrutiny of marks given to the individual candidates for every question?
My lord, in this
That
regard,
is
my lord,
whether that comes within the scope.
The past judgment, although I have, my lord, pardon me, my lord, I have only one copy. That
No, you
my
give
lord,
us two
yes,
copies.
my lord,
We
obviously,
will not pardon you.
Not true, my lord. I just
For that, we will not pardon you. For other things, we can pardon you.
I just yes. My lord, it is yes.
Yes, not
And following this input, yeah, আমাদের হাইকোর্টের ডিভিশন বেঞ্চে কোঅর্ডিনেট বেঞ্চ অর্ডার প্রতিভা
Yes.
It's only one judgment. I have asked him to take out the court. High Court is not permissible. Judgment.
High Court in ये বের কর প্রতিভা মণ্ডলের ডিভিশন বেঞ্চের জাজমেন্টটা বের কর। মানে in similar type of situation, coordinate bench passes several judgments, and High Court constitute the committee also.
Have you seen judgment of the Apex Court delivered? Run Vijay, yes. His Lordship Justice Madan Lokur's.
Yes. And my last occasion, my lord says it, my lord.
You have got it?
Yes. My lord, the fact is that, my lord, one is that, that's why, my lord, I want to make submission, my lord. One is that, my lord, we thought of that, the whatever the authority, Article 12 authority, said the answer key, that is the sacrosanct. Another thing is that, my lord, the looking of this matter, my lord, That is not a sacrosanct, because in nowadays, my lord, there are several type. I will not go into that matter, my lord. There are several type of corruptional routes. Suppose I give an example. What is the name of the capital city of India? Might be four option is there. The right appropriate answer is New Delhi. If the paper setter or the Article 12 authority says no, it is Kolkata. Once upon a time, it was a Kolkata, but now it is not a Kolkata. So must be the third party, the expert committee constituted, and they analyzed it, because the court might be the expert of all experts, but court is not the expert. For that reason, in other matter, Calcutta High Court, even Calcutta High Court coordinate bench, division bench, very, very recent, TET 2017 and TET 2022. I bring that order also. That recently, with the coordinate bench publication, very elaborate one, very recent. This type of situation, by quoting this Kanpur University, coordinate bench, exactly on that issue, whether reassessment is permissible or not. And Ranvijay is also considered in the coordinate bench. Ranvijay, Rahul Singh, all are considered. Look at the
এক্ষুনি দেখবো, এক্ষুনি পড়বো, এক্ষুনি মামলা করবো।
Monish Ujjwalটা বের কর। Monish Ujjwal, Monish Ujjwal দুটো কপি। জাস্টিস হরিশ্চন্দ্রনের কপিটা বল। জাস্টিস হরিশ্চন্দ্রন এখনই বের করলাম তো।
This is against an interim order. This is not a final order.
But my question is that, my lord, whether on the issue that whether it is subject matter of judicial review or not, my lord, the coordinate bench observation is a subject matter of judicial review. That's why, my lord,
please go through.
My lord, my intention.
Ran Vijay, Mukesh Thakur, both have been noticed. His lordship has clearly said that there is no scope for the writ court to venture into this, but there is no absolute embargo.
Yes.
He has said both things. Then he has proceeded on the point that several directions were passed by the division by the single judge, which have been complied by the respondents.
In this case also,
Therefore, that interim stage, he says, instead of this, this can go on. Yeah, that issue has not been answered in the affirmative. It could not have been.
in this
Law
case,
is now clear. Mukesh Thakur and Ranvijay Singh.
my lord, kindly see in this
This
case,
is not the court's domain to go into every
it-
question to see which is
depends on
correct and which is incorrect and how many marks are to be given.
In this respect, I got a judgment. May I please? Lordship, this is Himachal.
Yes, that is Mukesh Thakur.
Yes, Lordship, Mukesh.
That's what we are saying. Ranvijay Singh and
my lord,
Mukesh Thakur.
in this case, my
Where
lord,
it is written that High Court cannot go into the question
Yes,
of
madam,
evaluation.
Ranvijay Singh is perhaps after that.
my lord, in this case also, out of 4 questions, my lord, they not give 2 marks in their own volition. After taking it,
Therefore, they have all the more that is an indication of the bona fides. If they have found that there is a deprivation, they have set it right.
then my lord, their decision must not be sacrosanct. Why? Because of that, my lord, that means
See, no decision is infallible.
Obviously,
the point is where the writ court is to enter. That is the point.
Yes.
That is the primary issue is it a subject of judicial review or
yes,
not? That is the only.
the prima facie, my primary point is that, my lord,
This
they
does not
already
help you.
given.
This is nothing. This is only at an interim stage.
Yes,
There is no declaration.
Justice judgment and Justice Pratibha Mandal bench. Pratibha Mandal justice. My lord, in this regard, my lord, I came with that Honorable Justice Subrata Talukdar division bench, my lord, passed the final judgment in this regard, my lord, regarding TET 2014
Sir,
wrong question.
whether a coordinate bench will prevail or the Supreme Court will prevail. When the Supreme Court starts, that just see the opening line of that judgment.
But the
Ranvijay Singh.
But considering the Ranvijay, my lord,
First line.
the motion
see
of
what
matter,
it
my lord,
says.
the motion of matter, my lord, already coordinate bench passed the
You have
order.
Ranvijay Singh.
And my lord, in the factual aspect, my lord, other candidate already gave half marks.
There is one more judgment where Ranvijay Singh has been affirmed. It's 2021, Lordship.
Yes, that is now the consistent view.
No, my lord, with
In
deepest of
this
respect, my lord, with deepest of
stated by the apex court.
my lord, with deepest of respect, my lord, from Kanpur onwards, my lord, considering the Ranvijay, my lord, this court time and again regarding TET 2014, TET 2017, TET 2022, my lord, each and every matter, my lord,
maybe,
my lord, the coordinate bench, the single bench, pass the judgment. Thereafter, upholding that single bench judgment, division bench passed the judgment, and in pursuance of that, Article 12 authority gave the
law stated by the apex court is binding on us.
There is conflicting views, my lord. With deepest of respect,
we have not seen any conflict with this. This we will consider. Don't worry. We don't see any conflict.
Now, in this regard, factual aspect, other candidate got half marks.
Maybe.
But if other candidate got half marks, why I do not? This is equal opportunity in public employment.
That we have understood. Your submission we have understood.
Second thing is that, my lord, whether their selection, if they give me their answer sheet, there I will be more appropriate whether their answer is right or wrong. In other textbook, that's the reason.
That is where we say whether the model answer is right or wrong. Whether that is a subject of judicial review is now settled by the apex court.
In Kanpur University,
and we will consider. Don't worry, Kanpur also we have seen and we will again consider. We have seen Mukesh Thakur, we have seen Ranvijay Singh, we have seen Kanpur. All these judgments.
In mostly as well as in Pratibha Mandal.
Yes, that also. All those judgments we have.
I have a single bench order, but it will be kind
enough. Please don't.
I know.
Please don't do that.
Page 309.
Judgment.
Ranvijay Singh is of which year?
Ranvijay, my lord,
2018
2
SCC 357.
and my lord, Rishal.
2018.
2 SCC 357.
And Mukesh Thakur is before that.
Mukesh Thakur is Lordship 2010 6 SCC 759.
2010 6.
Yes, Lordship.
Page.
759. And in this judgment, Ranvijay Singh has been affirmed.
Has to be. That is why that was the judgment that we were asking you why you have not come with the judgment. Have you got the judgment now? Have you got Ranvijay's judgment?
I'm downloading it.
Another judgment, my lord, may I hand it over?
Read the first line of that judgment. What the apex court says.
Another judgment, that is, my lord, Monish Ujjwal. Monish Ujjwaler একটা copy দেন। My lord, and may I hand it over the Monish Ujjwal by considering the Kanpur, my lord. Considering the Kanpur, Monish Ujjwal, my lord, 2005 13 SCC.
Please make a compilation of the judgments.
But that will be very
Please do it so that we can finally
yes.
consider the.
It-
You also compile the judgments. You also make a compilation.
That will be, I will compile with the contention with paragraph.
No, not that. Just make a compilation. One place.
Yes,
Get it bound together chronologically. So that
from
we can-
year wise.
Yes, that is all that is required. Nothing else.
May I do one thing, Malay? One short, not more than 2-page written notes of argument.
Sir, if we will consider everything you argue, don't worry. We don't want notes. We don't want notes. We will write the order here in your presence. If anything is missing, you will point out. Don't worry. That's why we are saying if the judgments are given, compilation, then it can be done in court.
That's the help.
Otherwise, CAV and then,
That's the help.
the
Item number 10.
Lord, I am appearing on behalf of the petition. Filing my affidavit of service. Lord, petitioner has come before your lordship for compassionate appointment. Lord, petitioner's father the petitioner father was working as constable under
his father
Hill and Home under Home and Hill Department.
Home and Hill Affairs Department.
Hill Affairs Department, my lord. He made accident and succumbed to death on, my lord, 29th March 2009, and soon thereafter the mother of the petitioner has applied for compassionate appointment 2nd April 2009.
2nd
April 2009.
April
2009.
Yes.
Well, thereafter, when the all compassionate appointments are pending, well, the department has directed form a 3-man committee and asked the 3-man committee to consider all the pending compassionate appointment. Your lordship kindly come to page.
Yes. So what after that? What happened?
A 3-man committee has recommended my name,
Very
but
well.
the Lade tribunal has passed the order without considering the 3-man committee. Then my humble submission.
So if it has recommended your name, why did you come to the tribunal?
I come to page 39. Thereafter, no implementation was made. Okay, that's why, my lord, we went before the tribunal.
What is the date of 3-man committee report?
The 3-man committee's report is at, my lord, page 46.
What is the date, sir? We are asking.
Date is 27th June 2018.
18?
Yes. Kindly come to page 46. One. Starts from 45, 3-man committee's report. Kindly first see serial 2, Akash Ranjan Rai, son, the remarks petitioner, page 45. Now your lordship kindly come to page 46, clause 12. In this case, wife of the deceased employee was more than 52 years of age. Children were minor at the time of death of government employee. In this case, the candidate Akash Ranjan Rai was eligible for employment as his mother was submitted application for employment in his favor. Tania Rai, daughter of deceased government employee, was also minor at that time. Thus, belated request clause 10A of 26 EMP dated 1st March 2016 Labor Department Government of West Bengal is applicable here in respect of the candidate of the Akash Ranjan Rai. As the late government employee constable Vikas Ranjan Rai died while on duty. Now your lordship kindly come to the order passed by the tribunal. Thereafter, my lord, page 54, without considering that Deputy Secretary has rejected my claim on 23rd February 2021. Undersigned is directed to inform that Sri Akash Ranjan Rai, late Constable Vikas Ranjan Rai, is not under consideration zoned to the post of the LDC as per available vacancy at present.
Not rejected. Don't say it is rejected. Is not in the consideration zone because vacancy is not available. You are saying rejected.
But what is a very objective of the mother compassionate appointment?
So without vacancy, they should appoint you.
No. That
what do you want?
Now your lordship kindly come to see.
Why you should be given precedence over other who are waiting in line before you? Why? That is the only issue.
Now your lordship kindly come to.
What do you want, sir? Come to this, that. What do you want? Where it has been rejected that you have come to the tribunal?
I come to the tribunal 2022.
When was it rejected?
It was rejected on 4th April 2024.
4th
April 2024.
Where is that order?
Well, at page 61. 61.
Which authority rejected your claim? Why did you go to the tribunal? How many times we have to ask you?
Well, they have not considered my 3-man committee's report is there, and thereafter, my lord,
What is your right that you want to enforce? Why you have filed the OA? Why you have filed the writ petition? What has you are aggrieved by which order?
Malad, we have come before this court for setting aside of the order.
You have approached the tribunal aggrieved by which order?
Yes, Malad, setting aside of the order passed by 24th August 2022.
24th August 22. Where is that? Show us.
24th August. Malad, at page 55. With reference on above, I am directed to state the proposal on the subject noted above was taken up and examined in the department in the light of notification such and such of the Labor Department with subsequent amendments made from time to time and case records available. The case also referred to the Labor Department of this government and department's observation why UO number such and such. This case does not fulfill clause 10A of the notification number 26 EMP dated 1st March 26 of the Labor Department related to the belated request as the application is prescribed format was not submitted within the stipulated period of 5 years. Accordingly, I am directed to state the government regrets its inability to approve this case for appointment under compassionate appointment. Without
Why you are not showing? This is what we wanted.
Without taking into consider the 3 months committee's report. This order suffers from perversity as well as the order of the tribunal also, not taking into consideration the 3 months committee's report.
So how it is more than 5 years?
Kindly come page 57 once, my lord.
How it is more than 5 years?
Kindly come page 57 once, my lord.
57. What is this? Page 57.
This is the may place, my lord.
Uh-huh.
Applicant has made application beyond 5 years.
So what is this page 57?
Annexed by the petitioner, my lord. This is the RTI information, my lord. Applicant has to apply within 5 years. They have applied.
Yes, within 5 years we have applied, my lord. Page 25. Page 25,
Almost
my lord.
after 7 years, my lord, they have applied.
No. Within 19th November 2013. 25 after attaining the age of majority, my lord. My mother applied for the same on the technical ground, my lord.
No, on
yes,
the
after
prescribed
inquiry was made.
application in the prescribed format on 15 February 2017, my lord, they have applied for. And another thing, my lord, you kindly come page 29, notification 2013, my lord. And 11 court said page 32, my lord. Page 30, place, my lord. Dependent members shall invariably attend the
minimum age of recruitment within 6 months from the date of death of incapacitated the concerned employee. They have
Subsequent at the pendency of the
they have to attain majority within six months.
but thereafter,
At the time of death,
At
age
the
of-
time of death, he was 13 years, 6 months. Then how the tribunal has said he was 4 years old?
that is wrong. Wrongly printed.
Not printed.
Typographical mistake.
Not typographical mistake, my lord.
It may be 14 years, 11 years.
No, he was 13 years, 6 months and 29 days. That was his age. EMP 26, if EMP 26 applies, then
2013 clearly says within 6 months.
what 13? You are applying EMP 26, 2016 notification.
Page 57 we have stated, my lord.
Your committee has recommended him under 10AA. 10AA is not 13, it is 2016.
Within 5 years they have to apply. They have applied after 7 months, 7 years, my lord.
Where is 26 EMP? 2016.
এটা চলছে না এই মনিটরটা চলছে না আলো জ্বলে
Yes, my lord, I'm relying upon one Supreme Court judgment.
Supporting your claim.
My lord, three-man committee's report has not been considered neither by the authority at the time of rejection of my claim, nor the tribunal has considered the three-man committee's report.
Yes.
My lord, I'm relying upon the Supreme Court judgment.
Citation to the
Number 103. My lord, kindly come to page 11. We are constrained to direct as above. We have found that in several cases, application for compassionate appointment on compassionate grounds are not attended in time and are kept pending for years together. As a result, the applicants in several cases have to approach the concerned High Court seeking a writ of mandamus for the consideration of their application. Even after such a direction is issued, frivolous or vexatious reasons are given for rejecting the application. Once again, the applicants have to challenge the order of rejection before the High Court, which leads to pendency of the litigation and passage of time, leaving the family of the employee who died in harness in large and in financial difficulty.
Why you are relying on this judgment? In this judgment, where is the application belated? You just hand over any judgment. They are raising an issue that you have not applied as per the scheme. You are relying on judgment which does not have that fact. Why you are relying on this judgment?
Say I within time I.
So why you are relying on this unnecessarily? You cannot just give any judgment that is there in your pocket, whether it concerns your case or it doesn't concern you. Issue is only whether you are required to apply on the prescribed pro forma within the time or not. That is the only. We are asking you what do you have to say. You are not saying anything.
Well, 2013 I have applied the same. Well, not in format.
When did, according to you, when did you submit the prescribed pro forma?
Well, so for
Where is that statement made by you?
Prescribed format I have filed it later on. But
when you have made it, what is your case? Show us from your pleading. According to you, what is the date on which you have submitted the prescribed pro forma?
All of that, on attaining the age of majority, an application was made by the mother of the petitioner.
Again, we are asking you, when did you submit the pro forma? What is your case? Don't read the entire brief.
2017, my lord, as per pro forma, I have applied.
What is the date on which in 2000?
March 2017.
1st March 2000.
But prior to that, my lord, after attaining the age of majority, I have applied the application. On the technical ground, my lord, my
he died in 2009.
Within time, my lord, we have filed it. At 2013, my lord.
Where is the three-man committee report?
All right, page 46. It is 2017, June 2018. After taking into consideration all the facts, grievance committee has passed the recommended the name of the petitioner, my lord.
Bye.
When did you attain majority?
But I attained the majority.
Date of birth is 95.
95.
What is the date?
After
30th August 1995.
Sorry?
30th August 1990.
Page 40 wala prescribed form.
What is the date?
30th August
30th
1995.
August 1995.
30.
30th.
38, 95.
30.
So in August 2013, you became eligible.
Within 5 years, my lord.
Prior to this order, P10, prior to this recommendation of the three-man committee, is there any order rejecting his case prior to this?
Rejected on 22nd, my lord. Second,
Prior to
24th August, no, no, my lord.
no, prior to that, no.
No.
Prior to that, there is no other order.
Other.
There is an office memo dated 11/12/2013 issued by the Superintendent of Police. Is it there on record? 11/12/13.
11/12/13.
You see, come to page 45.
45, my lord.
Clause 5.
Clause 5.
Yes.
Submitted 19/11/20 after attaining the age of 18 years or sent to GIP and phone number
11/12/13. Where is that? Is it there on record? What applications he has submitted on 19/11/13?
19/11/13.
First application she submitted in April 2009. Then in
Page 25, my lord.
25.
Yes, sir.
What are the enclosures with this document?
Mother has, after attaining the
What are the enclosures with this document?
Madhyamik admit, Uच्च Madhyamik certificate.
Madhyamik certificate as well as high secondary certificate.
Madhyamik and
High secondary certificate.
Madhyamik admit card and high secondary. In this profile.
Get the records. Come with the records of the three-man committee. Because the three-man committee, it has recommended. The DSP has recommended.
Notification not permitted, my lord.
Huh?
It says otherwise, my lord. But kindly come page 55. The order in challenge, my lord.
No. Come back to that three-man committee. Clause 5. It says
was further submitted prayer.
was sent to the office of Inspector General by this office memo. So Superintendent of Police has sent a memo on 11/12/13 for necessary instruction. What is that memo? And after that, the committee has found him eligible.
We shall bring the record, my lord.
You don't have these documents.
I have instruction, my lord. Some documents are there, my lord.
Is that document there? 11/12/13. Just see.
11/12/13, my lord. Lord, kindly consider this document.
Oh.
Another copy is there. একটাই আছে আমি দেবো ইনস্ট্রাকশন দেবো আপনার পুরোটাই
Oh, this is an annexure.
This is instruction.
Then you file it. You file it. Let him place it on record. The learned State Council is in receipt of instruction.
রিপোর্ট গুলো দিয়ে দিন রিপোর্ট ফাইল করুন। Edit করে ফাইল করবো এক্সেপশনাল না ফাইলে না ডাটা দিন লিস্ট
Item 11.
I'm for the petitioner, my lord. Well,
I'm appealing for Public Service Commission.
I'm ready for appeal. But my lord, but three documents are there in Bengali.
You want to rely on them?
Well, yes, I am relying, but full lordship give me permit me to translate, give the translate copy of three documents, which is Bengali representation.
Certain documents.
Item 12.
Well, Mr. Ujjwala is appearing, man. He's on lake. Man, may I just prefer 2 days accommodation?
Yeah.
Taken on recording. Copy, sir. Copy has already received.
Affidavit in opposition filed by the state is taken on record. No reply.
Item 13.
Report state. Mr. Komolis for appear for the matter petitioner. I am praying for 1 week time. His personal difficulties, my lord, he is not come.
Not today.
14.
Not today. Make your prayer loudly.
A very old man in our blood.
Item 15, seasoned, not old. Lawyers don't get old, lawyers get seasoned.
Justice Poritos Mukherjee, as his lordship then was, while he was appearing, called him, yes, I am C.C. Pajohuri Banda. On this day, Madam Lord, the state is the appellant. Petitioner.
State is the appellant.
Yes, state is
What
the
happened?
petitioner before your lordship.
What the tribunal has directed you.
Your lordship has already heard. Already heard there are several orders passed by your lordship, from the record itself. But what has happened, that this is regarding compassionate appointment. The second round litigation before the tribunal. The first round, then second round. Second round litigation for 6 years delay. And I have taken the point, Lord, before your lordship, that unless the delay is explained, then your lordship was pleased to pass an order directing my learned friend to come with an application that he has come with with a petition annexing the application for condonation of delay and what his order was passed before the learned tribunal.
When we have directed.
But that application has been filed by my learned friend, Lord.
I have filed.
Yes, and copy has been served upon me.
Oh yes, there was no trace of any application. You said that your instruction.
And Lord, kindly see, Lordship, kindly allow me to, Lord, kindly see the application annexed. The order, my Lord, at page 5 of the petition. No, petition. My Lord has got it, Lord. His petition order, page 5. The matter is taken up. It is an order dated 6th of January 2025. Matter is taken up by the single bench pursuant to the order of contained so and so notification in exercise.
Where is which page 5?
That this is his application, Lord.
My application, my
But your Lord, as per your Lordship,
no, small affidavit filed by the respondent.
My Lord has asked
filed
me.
a 5-page affidavit. My
Lord, this type of
last
application.
last hearing, I have filed one application.
This is the application. This is the application. Your Lordship, application affidavit.
Small affidavit, my Lord. Yes,
your Lordship has directed him to file an affidavit to that effect about the order passed by the learned tribunal regarding condonation and whether condonation application has been filed or not and what is the ground taken. Lordship, kindly see the order, page 5. There is an order of 6th of January 2025. Heard the Land Council reserved for orders. I do not know, Lord, whether thereafter order has been passed or not. And Lord, Lordship, kindly see the delay application, Lord, under section 5. And next, thereafter, from page 6. Lordship.
Oh, so application was filed.
Yes,
filed, but what was the application was filed?
That you have already shown, reserved, but application was filed.
Not after the original application was not disposed of.
What?
Yes.
This is a section 5 application in connection with
yes, kindly see.
In connection with the way.
Both of you are arguing side by side. Please have patience. Yes.
Your Lordship, kindly see the order. From the order, your Lordship will find page 5. MA 47 of 2024.
This is not after disposal. This is before disposal.
Before 2024.
This is before disposal. How you are saying after disposal? Disposal is much later in on 29 January. This is of 6 January. So this is not after disposal. This is before disposal.
1924 days delay, and this delay was not at all, whether at all condoned or not, because reserved for orders. Thereafter, nothing. And kindly see the explanation of delay. 2016 order was passed. This is a compassionate appointment, but I am taking the point that it is not a matter of right. It is a immediate hardship. Fulfill the immediate hardship. My Lord knows it.
At best, Lord, there is no whispering the order impugned that the application for delay was filed and condoned. There is nothing so. Your Lordship will not find, subject to correction, your Lordship will not find in the order impugned that that subject of condonation of delay has been considered or at all dealt with. There is nothing, no observation about this. So, my Lord has just now said that this order was passed after the order reserved by the State Learned Court. Therefore, my humble submission, Lord, subject to correction.
Why it was rejected?
My Lord.
Why his application for compassionate appointment was rejected?
Because your Lordship kindly see, the compassionate appointment, it is surprisingly the second page of the order, to find that despite such clear direction passed by the Additional Chief Secretary, still held such an application is an invalid application. A reason order, instead of accepting the fact of submission of the application within the permission time, only states that such an application is beyond the time limit as per rule and as per the order being so dated 3rd December 2013. The reason order completely ignores the notification of 2016. But I have taken the point, Lord, the matter of when the 16 come in the field, much after the cause of action of the petitioner regarding the compassionate appointment.
No, when his claim was rejected, when was his claim rejected?
Claim rejected, Lord, 2013. Rejected. And page 76, Lord, the observations.
Again, we are asking you when his claim was rejected. By the authority, by which order it has been rejected?
Same. Rejected, Lord, the order, page 81, the rejection order. Page 81 is the rejection order. But the date I have not found. But Lord, here, my Lord, in the date of COVID is 8th March 2017. Third March. Pursuant to the order of
Where is the date? Where is the date mentioned? From where do you get the date?
But, prior to that, Lord, page 80.
This is the covering letter.
Communication.
3rd March 17.
98 IC so Kolkata, dated 3rd March 2017.
So it has been rejected in 17. And OA has been filed in 22.
22. 22 and 2016 for the second wave was filed 2016. The said tribunal by the said order has been pleased to dispose of the said application, directing the principal secretary so and so to consider.
So in their compliance of that order, this order has been passed.
This order has been passed. I'm not the blood. I have taken the I have respectfully submitted before submitting before your lordship that if your lordship takes up the matter, the yes tribunal has passed the order. But at the same time, the affidavit, short affidavit he has filed. Here, from here, it is clear that prior to that, condonation of delay application was heard and order reserved. What is the fate of the order? We do not know. And there is no whisper in the milord, the order impugned that yes, condonation of delay application is 29 January. I am putting question to myself, milord.
29 January order does not record anything about the MA.
No.
It's not there.
But you kindly see the order impugned. The last page, last annexure. The matter is taken up by single bench present to our so-and-so notification power. Application has filed this application praying for setting aside the impugned decision so-and-so. There is nothing, but I have read entirely. Neither in the first paragraph nor in the last paragraph. And your lordship, subject to correction, your lordship knows it very well. Until and unless the matter is alive, because there is an inordinate delay, 1924 days delay.
No, how it can be from 2016 to 22? It will not be that long.
He has stated 1924. It is his statement, not my statement. His statement in the application 1924 days. 1924 days.
6 years. Oh yes, yes. It will be 19.
That is from 70. 20,
Yes, it is 6.
In the aforesaid facts and circumstances case, it is most humbly prayed. Your lordship may graciously please to.
Yes, it will be
1924.
It will be because it is 6 years.
6 years.
So it will be in about.
And there was no explanation at all.
Why you were sleeping for?
There is explanation.
No. No reasonable explanation, lordship kindly see.
You have already said yes.
I'm sorry.
There is also explanation, but that explanation does not, my lord, applicable to a hapless person. It's not a employment. It's not a disciplinary against the disciplinary proceeding. A compassionate appointment. A person having no means to live. How he manage the expenditure of the tribunal?
Father is paying pension. Why that he has stated. What is
Other is otherwise.
No, otherwise. Mother is taking pension.
17,000 rupees. She is getting 17,000.
Mother is getting.
Yes, mother is getting, correct.
What I am getting. I am nothing. Well, let it be remand back to the tribunal for
25 judgments. You see Devabrata Tiwari's judgment, State of West Bengal versus Devabrata Tiwari. This is not the way you should approach a compassionate appointment.
Well, it is. There is some question of law is involved.
No, we are considering, we are asking you. That's what we are considering.
Well,
6 years. It's not a question of 1 or 2 years. 6 years. The rejection is communicated to you. It is not that it's not communicated to you. For 6 years, you don't need the appointment, and all of a sudden you come and
17 to 18, 19, 20, 21, 20.
the date of
21.
the date. No, sir, 6 years. Rejection is of 16. You have moved in 22. It is 6 years.
There is no date.
Huh?
But the communication letter, here's the date.
Correct. So therefore, from communication, we are calculating.
From 17, 2017 to.
Show us date 17 from the communication.
Yes. Page 80, my lord.
Yes. What is the date?
3rd March 2017.
Very well. 17.
But the order does not, my lord, bear
5 years, more than 5 years.
order bears. This is a pure non-application of who passed the order, totally non-application. Right? Important when
Death has occurred.
passing a judgment.
And when death has occurred in 2009.
It occurs prior to that. We filed application within time. There is
No, you did not.
Yes, ma'am.
You filed application after 6 months.
That is also condoned by the tribunal, my
So
lord.
that was not within time. Don't say within time.
That was subsequently, my lord, ordered.
Don't say within time. It was beyond time.
Beyond time.
Yes.
But subsequently,
But you said we filed within time. That was wrong. Therefore, we are saying don't say within time. Yes. There was no 2 years at that time. In 2009, it was 6 months.
6 months. But the Honorable Justice Talukdar Singh.
So it was not within time. You got a blessing from the court. After that, also you have slept over it for more than decade. And you want a compassionate appointment. So those who really need it, they should get it. Why should you get it? You don't need it. This is not the way to approach a issue of compassionate appointment. The judgment is very clear. The recent judgment of the apex court. Yes, take down. The state is the appellant.
Item 16. I'm appearing for the state, my lord. 16.
My lord, I am appearing for the petition. As per your lordship direction, my lord, I serve the peace to my learned friend. Anyway.
You are for the respondent.
Yes,
Invitations are being sent to you. Why you are not appearing?
Notice the wrong seal.
My lord, in earlier notice, my lord, that was wrong, my lord, wrongly written down that
AGP.
or that is
Therefore, the lapse. Anyway, yes.
my lord, here the petitioner's reimbursement of the cost of the OPT treatment has been rejected.
Petitioners?
Reimbursement of the cost of the OPT treatment that was rejected only on the ground that is prior permission has not been taken by the authority.
What is the amount?
But there was a life-threatening situation.
What is the amount?
4,29,697.
609.
697. 429,697.
When the treatment was done?
In the year 2024.
What is the condition which was treated?
Well, that is the petitioner went for checkup, and there, my lord, the cardiac failure has been arrested, and then, my lord, immediately doctor prescribed to admit the hospital.
Cardiac failure?
Yes, my lord, that is vascular cardiac arrest, and immediate doctor has been prescribed to.
Where is that? That document is on record?
Yes.
Where is it? Shows? What are the rules governing such claim?
Rules, my lord. I am carrying the rules, my lord. The lords kindly go through the rules, my lord. Permission is necessary.
See, that must be there. Let us see. Normally, there is a residuary power vested.
First front page, my lord. It is Government of West Bengal Finance Department's order, my lord, dated 17 January 2022. It says, my lord, now last paragraph, last part one paragraph, third paragraph. Now, after careful consideration, the governor is pleased to implement online proceeding of application seeking prior permission for available treatment in enlisting hospital outside the state through WBSH portal. So this is the portal which has been opened by the state government for this purpose. So my respectful submission is this before your lordship that, my lord, petitioner was entitled to, my lord, fill up this form through portal, and it was available. Portal is always 24 hours available, but, my lord, petitioner was failed to avail this, my lord, system. And details of the procedure has been online proceeding permission such appendix A. It is there, my lord. I have annexed that also. So, my lord, it was available in our portal. So system is there, availability is also there. Petitioner has chosen not to, my lord, apply, my lord. It is, my lord, my respectful submission is this, my lord, it is his fault, my lord.
If there was a life-threatening situation, page 40 is my medical prescription. That immediately doctor prescribed me, but there is no scope for, my lord, filing the application. And I am covered by the latest notification that is published also by the finance department. That is,
My lord, if your lordship kindly go through this notification, answer is there, my lord. If your lordship kindly takes this, my lord. This answer is there, my lord.
But I already
Rule
annexed
11, my
the
lord.
supplementary affidavit also. Two schemes.
Rule 11, my lord. Rule 11, my lord. Page, my lord. Third last page, my lord. Rule 11, it is the notification of Government of West Bengal Finance Department Audit Branch, my lord. Rule 11. my lord, intimation of the medical attendance and treatment. It says, my lord, an employee shall give an intimation to the head of the office within 3 days of the commencement of this or his benefits of medical assistance and treatments, provided that such and such. So, my lord, he got 3 days time. Emergency was there, super emergency was there. Be that as it may, my lord, he got 3 days, my lord. But I don't know how may I address, my lord.
How, where have you read 3 days?
My lord, it is, my lord, point number 11 from the second line. It is, my lord, last 5 page. From last, it is 5th page.
Yes, intimation.
Yes, my lord. Here, I'm grateful, my lord. Second line, my lord. Middle. And my lord, second paragraph, my lord, proviso is there. Rule 11. Provided that where an employee himself is undergoing medical assistance and treatment and not in a position to intimate personally, any member of his family may such give intimation. My lord, it is also there, my lord. Any member of his family can do this.
So you have undergone the treatment on which date?
My lord, that is page 40. My lord, from 6/2/2024 to 9/2/2024, 9 February 2024. I admitted 6 February 2024 and I discharged 9th February 2024. That is page 38. And page 39 is the reasons for admission.
6/2/24.
Yes, 6th February 2024. Discharge on 9th February 2024.
And when did you make intimate them?
I made a representation before Mala 23rd February 2024.
23/2/24.
Yes.
And there is a rejection order.
Yes.
Where is that
There is
order?
a rejection order, page 56.
There is a separate provision for outside the state.
My lord, I am coming there. If my lordship kindly say my supplementary affidavit, the first scheme came into force in the year 2008. That my learned friend showed before your lordship.
Yes.
And then supplementary and then, my lord, in the year 2014, my lord, the scheme came into force by modifying the name. If your lordship kindly see for a moment my supplementary affidavit, page 6. Page 5C is the 2008 scheme. On the basis of that, they rejected my claim. 5C, that is in the year 2008. My learned friend also saw it before your lordship that scheme. And subsequently, page 6, the new scheme that is came into force in the year 2014. If your lordship kindly see 6. This scheme may be called the West Bengal Health.
Page
6 of my supplementary affidavit.
Yes.
Short title and comments. The scheme may be called the West Bengal Health for All Employees and Pensioners Cashless Medical Treatment Scheme 2014. That is, if your lordship kindly see page 7, see clause E, existing scheme 2008 means the West Bengal Health Scheme 2008 and includes all subsequent orders issued to implement or clarify the existing scheme 2008. And here, my lord, the tenure for filing the application for reimbursement of the OPD treatment, cost of OPD treatment prescribed in clause 5, that is page 10. Page 10(1). The treatment and medical attendance which are not covered by these schemes shall continue to be covered by the existing schemes 2008. The cost incurred on account of related medical attendance and treatment received in a hospital or an institution during the period up to 30 days prior to hospitalization and 30 days from the date of discharge shall be reimbursed as per the provision under the existing scheme of 2008.
No, what we are asking you, both of you, to show where is the separate provision for treatment outside the state.
The outside scheme, my lord, that is also here, and my lord, my hospital also under this scheme.
See, the impugned,
So there is no another.
the impugned order,
Yes.
it is only taking notice of the fact that you have gone outside. Why you have gone without intimation?
Yes.
That is the order. So under which provision there is a distinction that if you go outside the state for treatment, you are required to give a intimation. Therefore, we are repeatedly asking you, come to page 56.
Page 56, that is the impugned order.
Yes.
Yes. My lord,
On scrutiny or no copy of prior for treatment outside state. So this outside state treatment is to be done with a prior intimation. Where is that provision?
my lord, that was not anywhere. My lord, some of the hospitals name outside of West Bengal, that is.
Is there any provision making a distinction between inside state and outside state?
Outside state, some hospitals are there that is under this scheme. If your lordship kindly see for page 68.
We are, if you will please hear us for a second, then you will give the reply that we want to know whether there is any provision in 2008, 2011. There are many. 2008, 2009, 2013, 14, 18. There are many notifications issued in 15 also. Where is the provision which says that for outside state there is a special procedure?
There was no.
In which notification?
And my lord, 2018, my lord, in favor of me, I am covered by 2018. There is, my lord, governor.
You are Mr. You are defending page 56. So read page 56.
My lord, if your lordship, my lord, kindly takes the notification which was produced by me, my lord.
Yes.
Dated 17th January 2002.
Yes.
Your lordship kindly takes it, my lord. I am reading, my lord. It is third paragraph. Now, after careful consideration, the governor is pleased to implement online proceeding of application seeking prior permission for available treatment in enlisted hospitals outside the state. My lord, kindly underline.
So in January 22, this has been introduced.
And he is the candidate of kindly take page 55. Kindly take page 55 of the his petition. He says, my lord, is dated 22nd December 2024. It says, my lord, this period of treatment is, my lord, 6 February 2024 to 9 February 2024. So, my lord, these bound to cover by this notification of 2022. And it clears, it is very clear, my lord, from this. Seeking permission is necessary, number one. And number two is, my lord, outside of the state, which was query fallen from your lordship.
There was no scope, my lord, to apply for prior permission. I went to my lord for my health checkup, and life-threatening situation arises. For that reason, there was at all no scope.
Lord, also my lord says that the relative
online process of application seeking prior
can do this within 3 days.
or
This reward was also.
enlisted hospitals outside the state. The details of the process.
Procedure. Where is the requirement? This says that the procedure is hereby laid down for online application of prior procedure. You read the subject of that notification. Introduction of online functionality for seeking prior permission of availing treatment in listed hospitals outside the state. So this application earlier was not made online, it was made offline. Now it's in online procedure has been introduced, but where is the requirement?
Lord, Lord, this is the notification of Finance Department, my lord, Rule 11. My lord, I have produced this, my lord. It says, my lord, Rule 11. It says, my lord, intimation of medical allowance and treatment. All employees shall give an intimation to the head of the office within 3 days of commencement of his or his benefits medical attendance and treatment, provided that where an employee himself is undergoing medical attendance and treatment and not in a position to intimate personally, any member of his family may give such intimation. So intimation is required as per rules. And my lord, 2002 memo also says, my lord, that he can avail the scope as per under the
Give a compilation of all these notifications.
My lord, page 75 for a moment. My lord, kindly see for a moment the notification which Finance Department subsequently
my lord,
published.
I am just again, my lord, I am beseeching before your lordship to see, my lord, order dated 17 January 2022. It also covers this notification. It says, my lord, first, I am reading for first line. At present, the enrolled employers or pension such and such has submit their annual application seeking prior permission to avail urgent treatment is enlisted hospital West Bengal such and such of the administrative department such and in terms of this notification, my lord. This is the notification.
So where in that notification it says for outside state prior intimation is required, for inside state no prior intimation is required. That is what we are asking you.
My lord, it says, my lord, subject to kind correction of your lord.
No, whatever it says, the relevant thing is that where does it lay down that prior intimation is required for outside treatment? Just show us.
My lord, page 75 is the regarding my lord offline application.
It is general, my lord. It covers, my lord, inside and outside. My lord, may I read once for your lord?
So therefore, now again you are defending a order which is at page 56. You read that order, what it says. That is the order that you are trying to defend. It says because it is outside and you have not made it prior, therefore it cannot be. Where is the requirement? Outside state. So therefore, where is their distinction in the rule notification that once you go outside, it has to be with prior intimation? In second paragraph, in third paragraph, everywhere stress is on outside treatment. Now, supposing somebody is outside the state and he falls critically ill, then how he will get a prior permission?
Through online.
So for facilitating that, the online portal was opened. But where is the requirement? That is, the process has been made simplified to fulfill which requirement? Where is the basic requirement that once you go outside, it has to be?
2008's memo, my lord.
Please read for yourself. Don't just say what you are being instructed to say. If you want to answer the court's query, you are required to go through it yourself. That is not the way that you can assist. That from back he will say something and from side he will say something and you will show one line from here and one line from there. That is not the way. No, you go through it. You compile all the notifications in one place from 2008 onwards. Then we will consider. The short issue arising for
ওকে দেবো 28 তারিখের মধ্যে 5 তারিখ গ্রেট
Yes.
Item 17.
Your Lordship, Mr. Gurdu Singh is appearing in this matter. He had to leave the court because of some personal difficulty.
My lord, on the last occasion, same prayer was made. Terminal benefits, my lord, has been deprived. Last occasion, the same prayer was made. He has to leave the court. Terminal benefits, my lord, have been deprived by the my lord widow. At this matter, my lord, at length on 22nd September, your lordship directed the petitioner to inquire. My lord, I took a point that they are getting pensions. Both are, my lord, pension holders.
Anyway, we have, this bench has not considered it. This bench will have to consider it. Not today. You will have to refresh everything.
Item 18. I'm appealing for the state.
That I appear in this matter for the petitioner. That this is relating to Lord, prayer for study leave by a pharmacist serving under the state of West Bengal. Now, Lord, he has fulfilled the conditions for getting study leave, but leave is not being granted.
Under the TR rules,
Yes. Lord, just
there is a rejection order
yes,
by the authorities.
yes,
Should we come to the rejection order?
yes. Lord, your lordship, kindly have a look to Mr. Westwood. Rejection. Page Lord, 124, reasoned order. Page 124, this is the second time rejection, Lord. Lord, yes. Lord, page 118 is the first rejection order which was set aside by the learned tribunal.
My lord, may I submit one thing, my lord? There was a direction for affidavit in opposition. My lord, I could not. Today I have received instruction, my lord, time may be extended for filing.
Let them file.
Lord,
The affidavit in opposition was required to be filed.
Item 19.
My lord, I am for the petitioner, my lord. My lord, at the outset, my lord, I submit that it is not an adversary litigation before this honorable court at least. My lord, we have come up being aggrieved because two-member bench is not being constituted. Points of law are involved and the honorable learned single bench held sitting in the state administrative tribunal of the single bench held that complicated questions of law are involved. So, 2-member bench, 1 judicial member, 1 administrative member should be constituted to hear out this matter. On this score only, the matter is pending and is being adjournment is being given one after the other. So this is the crux of the matter, my lord.
Which order is impugned?
My lord, in fact, the whole orders are impugned where times have been allowed, one after the other, adjournments have been allowed. And the order of the tribunal itself have not been carried out, where the order of the tribunal says, my lord, constitution of bench, my lord, at page 61, my lord, kindly cease. April 2023 order, my lord. But I'm coming to the last portion of the
I'm not appearing in this matter. Appear close. Did petitioner stop?
So interim order is not continuing anymore.
my lord, my instruction is continuing, my lord.
How it is continuing? This is not your conference room, sir. You are supposed to respond, not asking for every query that the court makes to you.
I stand corrected. My lord, kindly cease. The next page, my lord, page 63, my lord.
Come prepared. Go through the brief. Not today.
My lord, in this case,
Not today.
take it up next
No,
day
sir.
after tomorrow.
Sorry.
Day after tomorrow, my lord.
No.